You filed a non-provisional application months ago, and nothing has happened since. No letter, no update, no sense of where the case stands in the queue. So this explainer walks through exactly what is happening during that silence and what to expect at each stage from filing to grant.
Section 1. The unexamined application queue. So, while total pendency to a granted patent runs about 24 to 36 months under standard examination, you'll typically wait 18 to 26 months just for the first office action to arrive. That massive initial wait is driven entirely by the sheer size of the USPTO's unexamined application backlog, which currently sits above 800,000 applications. When you submit your file, it enters this vast unexamined inventory based on its assigned technology art unit, and cases are generally examined in the order they were filed.
And pendency is unfortunately getting longer, not shorter. While fiscal year 2024 averaged 19.9 months to the first office action, fiscal year 2025 actually rose to 22 to 26 months in several technology centers after a federal hiring freeze stopped examiner recruitment. The current reality for most applicants is a wait measured in years, not months.
Section 2. The first office action.
Now, during that long queue, examiners aren't just sitting on your file. They are conducting exhaustive prior art searches across patent databases and scientific literature, which is highly demanding in complex technology areas. Because this first office action represents the examiner's complete, defensible analysis rather than just a preliminary comment, USPTO data shows that 85 to 90% of non-provisional applications require at least one office action response cycle before allowance. A single round of back and forth with the examiner is the standard norm, not a red flag.
Section 3. The response cycle timeline.
When the office action issues, you have a statutory 3-month response period. But here is where we actually have some measure of control. If we submit a fully responsive reply within 1 month, instead of waiting out the clock, the examiner takes up your response sooner. Responding faster directly compresses the timeline at the next stage.
If you want the full breakdown of what happens at each stage, including the exact Track 1 fee schedule by entity size, the full article is linked in the first comment below.
Section 4. Final rejections and RCEs.
If that first response cycle does not fully resolve the examiner's rejections, you will likely receive a final office action, which forces a very heavy strategic decision. To continue arguing substantive changes, applicants often must file a request for continued examination, or RCE, under 37 CFR Section 1.114. This procedural filing essentially reopens prosecution, allowing the examiner to issue a new non-final action. But that extra cycle comes at a severe cost. Filing an RCE adds 12 to 18 months to the queue on its own. It pushes the average total pendency to about 44 months, compared to just 26 months for cases that reach allowance cleanly without one. It is a major commitment of time and resources.
Section 5. Track 1. Prioritized examination.
If your commercial timeline is tied to a funding round or a product launch and simply cannot survive a 3-year wait, the USPTO offers legitimate acceleration tools. Track 1, Prioritized Examination, is a paid program that moves your application to the front of the queue, typically compressing total pendency to 6 to 12 months for cases that qualify. The specific fees vary by entity size, running $4,515, $1,806, or $903. Just keep in mind, this only changes your place in line. The rigorous analysis remains exactly the same.
Section 6. Controlling your prosecution strategy.
So what can you actually control in a process that mostly feels entirely out of your hands? Aside from paying for Track 1, our best levers are applied early. File a complete, well-drafted application, submit a comprehensive information disclosure statement on day 1 to reduce the examiner's search burden, respond to actions promptly, and strategically use examiner interviews rather than just trading paper back and forth. When facing a final rejection, we evaluate specific alternatives before ever committing a client to the massive cost and delay of an RCE. Step 1 is often conducting an examiner interview to clarify exactly what claim language would resolve the rejection. Step 2 is considering a pre-appeal brief request for review if the rejection involves a legal or procedural error. Step 3 is committing to an RCE only when substantive refinements are absolutely necessary.
The single most important takeaway from this entire process is this: the timeline is long and largely outside your control, but the decision of whether to file an RCE or pursue an alternative is the biggest lever you actually have.
The article covers exactly when a pre-appeal brief request for review or an examiner interview might be worth exploring before committing to an RCE, and that full reasoning is in the first comment. Subscribe if you want practical USPTO and patent guidance without having to search for it each time, and ask yourself, are you treating your application filing as the finish line or the starting point of your strategy?